I'm John Blue, and in 1981, I argued a case in the Supreme Court called Little versus Streater. It was a paternity action, and the question was whether an indigent defendant in a paternity case had the right to blood grouping test at state expense. This was before the age of DNA. The court held in my favor 9-0, and I'm very pleased to say it was a case that going in, many legal minds told me I could not win it. And significantly, this was the last all-male United States Supreme Court. It was interesting because it was a paternity case in which I represented a male defendant who said that he was falsely accused, and that probably gained some sympathy in an all-male court. In terms of my most vivid memory of the court, what I most remember is the fact that when you stand up at the lectern, it's a horseshoe-shaped bench, and all the justices are looking at you, and they're very close, much closer than you are to the bench in the Connecticut Supreme Court or the Connecticut Appellate Court, for example. And their personalities came through. White was very gruff. I remember Stewart, who had just quit smoking, was chewing rubber bands. I thought he was chewing gum, which I didn't think was great judicial demeanor, but I understand why he did it. Blackman was a little shy. Powell was the picture of Southern courtesy. Rehnquist had some humor. Stevens was very bright and very inquisitive. And I was told of Chief Justice Berger that you have to count on the chief asking one dumb question during every argument, and that prediction was fulfilled. At any rate, the other thing that was interesting was a very rarefied atmosphere for a paternity case, because these were kind of political and corporate types. And none of them, I think, except possibly Marshall, had ever been involved in paternity litigation in any capacity. And they had a lot of practical questions for me. And for me, the most significant substantive part of the argument came when Justice White, who was kind of the Anthony Kennedy of his day and was the swing vote, asked me, well, your client is indigent now. Why, if he gets some money later, can't he go in and get a paternity test? And I explained it was because to get a paternity test or a blood test, you had to have the mother and the child as well as the father, and that couldn't be arranged without an existing case. And plus, you don't want the child growing up for several years thinking that one person is his father, only to find out later that another person is his father. He nodded his head. It satisfied him, and I really felt that had won the swing vote in the case. At any rate, I look back on it, maybe through the fortuity that I won, with great satisfaction, and I feel very fortunate to have experienced our judicial process at its very highest level.
My name is Linda Lager, and on October 13th, 1982, I argued the case of Connecticut versus Johnson before the United States Supreme Court. I really want to start off by giving credit also to the person on the other side of that argument, a former colleague of ours, Gerald Barnett. Jerry, at the time, was the chief of the appellate division for the Public Defender's Office, and he and I had had a long history of arguing cases against each other in the Connecticut Supreme Court. And we probably wouldn't have gotten to the Supreme Court if it weren't for Jerry in a kind of an odd way, because this was a case in which part of the conviction was set aside by the Connecticut Supreme Court on the grounds that the jury was given an unconstitutional jury instruction that required them to presume intent from conduct, a mandatory presumption, in violation of a case called Sandstrom versus Montana. But he thought the Supreme Court should have reversed the entirety of the case. So he petitioned for cert, and of course, I, on the other side, as a representative of the state of Connecticut, was required to respond to that petition. And because the facts of the case were particularly horrendous, this case arose from an abduction in Norwalk of a young woman who was then brought to New Haven, where she was gang raped and then tied up and thrown into the West River. she managed to survive it and was able to identify the defendant in the case, Lindsey Johnson, at the trial. But Jerry thought the rest of it should have been set aside as well. So I had to make a decision. Will I respond to his petition for cert, or will I cross-petition? And I decided to cross-petition. The other thing that was very interesting about this case, I was a young woman at the time, and in the year before, only 23 women had argued before the Supreme Court. I argued in October term 1982, which was a hallmark for any number of reasons, including the fact that Sandra Day O'Connor was then sitting as the most junior justice on the court. Women made up a very, very small portion, obviously, of the people who were arguing before the Supreme Court. And that was sort of a big thing at the time, and there weren't that many women lawyers, certainly, at the time either. So the issue in the case was whether the constitutional harmless error doctrine of the case of Chapman versus California applies to errors in jury instructions, and specifically whether a mandatory presumption would be subject to that doctrine. The outcome was a little frustrating. It was a plurality decision. 4 justices thought it was covered by the constitutional harmless error doctrine. 4 justices thought it was not. And Justice Stevens thought that they shouldn't have taken the case in the first instance. If there's a plurality, and Justice Stevens voted with the ones who said that they should affirm the Connecticut Supreme Court, I lost. But what was satisfying is that 4 years later, in a case called Rose versus Clark, the Supreme Court decided the precise issue of whether Chapman harmless error rule applies to a Sandstrom versus Montana presumptive intent jury instruction error. Pyrrhic victory, but nonetheless, I was right on the law, and that made it a very satisfying experience in the end.
Good afternoon. My name is Carl Schumann. I'm a judge of the Superior Court, and in 1986 I had the good fortune of arguing Kelly v. Robinson. Mrs. Robinson was convicted right here in New Haven of welfare fraud and sentenced to make restitution of $9,000. Virtually the next day, she went across the street and got a very good lawyer, Frank Deneen, at New Haven Legal Assistance, who decided to file a petition for bankruptcy and try to discharge the restitution obligation. And she did that, and the probation office didn't do anything because they weren't really familiar with what a bankruptcy notice was. And 3 years later, they sent her a notice, you haven't paid your restitution, and she then filed an adversary proceeding in bankruptcy court to have the court determine that her restitution was discharged. That's when I got notice of it, and I went into bankruptcy court for the first time and argued that it wasn't a debt. The bankruptcy court agreed. Frank Deneen appealed to the district court, which agreed, and then he appealed to the Second Circuit, which reversed the district court and held that restitution is a debt that's subject to discharge under bankruptcy. On behalf of the state, and I was an assistant state's attorney at the time, I petitioned for cert in the United States Supreme Court, much to my pleasure, although somewhat terror as well, granted the petition for certification. And so I went down in November of 1986 and argued the issue of whether criminal restitution is subject to discharge in bankruptcy. And it was Justice Scalia's third day on the bench. He was seated over on the far right, and Justice O'Connor was returning as a sophomore, seated on the far left. And it was like a tennis match for me, being battered around with questions from the right and the left. But the toughest questions actually came from Justice Marshall, and that's Thurgood, not John. He was critical of the fact that Connecticut had not intervened in the bankruptcy court in a timely fashion. And he asked me, well, don't the probation officers have any good lawyers who can go into bankruptcy court and file a timely objection to discharge? And I said, well, at the time, it was the first time this had happened. We were perplexed by it. We were a little confused. And he ended up quoting me in his dissent, and saying that Connecticut state agencies were admittedly somewhat confused on how to handle it. And he said that we seek a confusion-induced waiver. But the majority held 7-2 that restitution is not subject to bankruptcy discharge under Chapter 7. I actually relied on an alternative argument rather than establishing that restitution was not a debt. I established or tried to that restitution was not a fine, penalty, or forfeiture that was subject to discharge. And I had argued for somewhat of a broad construction of that statute, which was difficult to law enforcement, strict constructionist-minded justices. But I think common sense prevailed, and we did win the case 7-2. It was a great experience, and I'm very fortunate to have had it.
The case that I argued in the U.S. Supreme Court was Connecticut versus Barrett. It began at the trial level when the state charged William Barrett with sexual assault in the first degree. Prior to his arrest, Mr. Barrett was at the police station where he made voluntary oral statements, but he refused to reduce those statements to writing until he saw an attorney. The trial court found that the statements were voluntary. The Connecticut Supreme Court found that Mr. Barrett had invoked his right to counsel and therefore reversed the conviction, and I filed a petition for certiorari. The U.S. Supreme Court agreed with me. It was an equivocal invocation of the right to counsel. The voluntary statements were admissible, and the conviction was reaffirmed. I had a very short petition for certiorari. I remember it was somewhere in the area of 7 pages, and the brief itself was short as well. It was a very finite issue. Were the statements voluntary? I relied primarily on the Fifth Amendment. Turning to the argument itself, I do recall the day of the argument vividly. You can see from the photograph that I provided that I was about 8 months pregnant. I was much thinner at the time, so it was obvious that I was 8 months pregnant. Before the argument, as I was seated in what I call the on-deck table, one of the elderly marshals approached me, tapped me on the shoulder, pointed to the anteroom, and informed me that there was a nurse on duty that they called especially for me. If I went into labor, they would whisk me right out of there and take me to the hospital. The other thing that relaxed me before my argument was the fact that the first argument of the day involved a claimant from Missouri who was arguing that pregnancy was an emotional, physical, and mental disability that required preferential treatment. And I vividly remember all the justices, especially Justice O'Connor, looking at me throughout her argument. My argument itself was relatively short. I wanted it to be because if the argument went beyond 1 o'clock, my rebuttal would have to be after the lunch recess, and I was determined that I was not going to go back into that building after the lunch recess. I didn't want to think for an hour about what mistakes I'd made. My opponent, Judge Doehr, was absolutely prepared and was brilliant in his argument, but thankfully, I won.
My name is Bob Gennario, and I have the privilege of representing William Barrett before the United States Supreme Court. My involvement in the case started innocuously enough. At the time, I was partners with now Judge John Kavanowski. He and I were just starting out. We had a contract with the Public Defender's Office to take appeals for cases in which there was a conflict. We got 3 cases, and Judge Kavanowski will tell you I picked the Barrett case because it was the thinnest file. Took an appeal to the Connecticut Supreme Court where we prevailed on the basis of a claim that Mr. Barrett's confession or certain admissions were made in violation of his right to counsel. The case was essentially a sexual assault case. Mr. Barrett had been arrested. He had indicated that he didn't want to give any written statements without a lawyer. And the police proceeded to take his statements, unsuccessfully tried to tape record them, wrote down his statements, and those statements were admitted to the trial level. We prevailed in the Connecticut Supreme Court. Surprisingly, the state petitioned for certiorari to the U.S. Supreme Court, and the U.S. Supreme Court granted certiorari. My impressions of the day are vivid in my memory, because I was, of course, planning on giving this philosophical argument about the holding in the case of Edwards versus Arizona, which I had relied on very heavily. I thought was squarely on point with our case, and the Connecticut Supreme Court had agreed upon me, and I was going to basically ignore the facts of the case. One of the first questions came from Justice O'Connor, and she was on the far left side of the bench. And I'm facing Justice O'Connor, and she is asking me these questions, and I'm doing my best to answer them, going into some of the facts about how the defendant's statement was taken. And I hear this booming voice that could be best described as a chain around my neck, jerking me back to the right-hand side. And, of course, it was Justice Scalia saying, "That's not what happened, counsel, is it?" Well, I actually thought that was what happened, but it went downhill from there. I often remind myself that in moments leading up to the argument, I tried to calm myself by saying, it's a 20-minute argument. How bad can I get beat up? Get beat up pretty badly in 20 minutes. And the justices of the U.S. Supreme Court certainly did a good job. In reflection, as I try to go back and reconcile my argument with the ultimate holding of the case, Justice Brennan, in a concurring opinion to the majority, best described the reasoning for the reversal, and that is that Edwards, as opposed to setting forth a bright line rule, was based upon its unique facts, and that each case needs to deal with the facts of the statement given by the defendant, and that on all of the facts involved in our case, the trial judge rightly found that the defendant had knowingly, voluntarily, and intelligently waived his right to counsel. The state won the case. We went back to the Connecticut Supreme Court, where I tried to convince the Connecticut Supreme Court that it was a violation of the defendant's rights under the Connecticut Constitution, but that was to no avail. Experience, from my point of view, unfortunately not so much from my client.
The case of Connecticut versus Doehr, where I represented the state, where Mr. Doehr was playing golf. It was a schoolyard, however, and a man by the name of John Don Giovanni came over and told him that, as the sign said, no schoolyard playing of golf. There was a pushing and shoving match that is, ensued, and Di Giovanni later said that he had a black eye, and he brought suit against Doehr, and he eventually got a judgment of $5,600 with 40% comparative negligence. He also obtained a real estate attachment ex parte against Doehr's house in the amount of $75,000. At the same time as this was going on, attorney Joanne Faulkner was collecting plaintiffs to go into district court to challenge the ex parte real estate attachment statute, Connecticut statute. She recruited a man named Pinsky. She also got Brian K. Doehr as a plaintiff. She lost in the district court on summary judgment, saying that the statute was constitutional, but then it went to the Second Circuit. And in the Second Circuit, for the first time, the state was notified that its statute was under attack, and we joined the lawsuit at that point. The Second Circuit found the statute unconstitutional and reversed the district court. However, there was a dissent by Judge John O. Newman. The Supreme Court took certiorari, and we argued the case. Judge, or I should say, Joanne Faulkner was there too, and she did a beautiful job. No, very few questions. With me, I was peppered with questions. Two little incidents. Justice Scalia was trying to work out in his mind, he had this original jurisprudence argument. Could a attachment be declared unconstitutional under the Constitution as written in 1787? And also, Justice O'Connor asked me a question, and just recently I saw a law review article where they said that she was cut off by Justice Rehnquist, and the purpose of the law review article is to say how difficult it was for O'Connor to question lawyers during the oral arguments to the Supreme Court. The case eventually was decided by Justice White, who was very interested in it, how attachments would go, and he ruled, he had two concurrences, but basically it went in favor 9-0, affirming the Second Circuit that the statute itself was unconstitutional. We did win one little point of whether a mandatory bond was required. White couldn't put together a majority there, so I could say that I had one little point that I did win.